Support for today's episode comes from Amazon. Amazon is working toward a carbon-free energy future, doing more with less, investing where it matters most, and supporting communities where we operate. DOJ moves to dismiss NCP lawsuit against xAI operations. The Justice Department didn't just decline to support this Clean Air Act case against xAI, it moved to kill it. The argument it made to do so is what should be getting attention from environmental and compliance professionals. The U.S. Department of Justice, DOJ, filed a motion asking a federal court to dismiss a Clean Air Act lawsuit brought by the NAACP and the NAACP Mississippi State Conference against xAI, the company behind the Grok artificial intelligence platform. The plaintiffs filed suit in April, alleging that natural gas-fired turbines powering xAI's Mississippi data centers are subject to environmental permitting and emissions requirements under federal and state air quality programs that the company has not met. They sought civil penalties and injunctive relief. Mississippi regulators had previously determined the turbines did not require the permits the NAACP alleged were triggered. The court has not yet ruled on the government's motion to dismiss. The DOJ's argument goes well beyond this permit dispute. The Justice Department did not simply argue that xAI was in compliance. It argued that private citizens and advocacy organizations should not be able to pursue Clean Air Act enforcement at all when federal agencies have decided not to act. The filing contends that allowing the case to continue would conflict with current federal priorities around energy infrastructure, artificial intelligence development, and national security. It also states that the Department of Defense, DoD, relies on Grok for certain AI applications and considers continued operation of the platform important to national security. That framing is a significant step. Clean Air Act citizen suit provisions have existed since the 1970s, precisely because Congress wanted communities to have an enforcement path when regulators weren't acting. The DOJ's position is essentially that when the federal government has determined a broader public interest is at stake, that enforcement path closes. If the court accepts that reasoning, the implications extend far past xAI. Any facility tied to AI infrastructure, defense supply chains, or federal energy priorities could use the same argument to resist citizen-initiated environmental enforcement. Why this matters for EHS and compliance teams. Tracking AI infrastructure. Data centers are the fastest-growing category of new industrial load in the U.S. They require significant power, and that power increasingly comes from on-site or adjacent gas generation deployed quickly and sometimes outside the standard permitting sequence. The xAI case is the first major instance of the federal government intervening in environmental litigation to protect that model on national security grounds. EHS and compliance professionals at facilities near large AI infrastructure buildouts or at companies supplying power to them now have a cleaner picture of how the current administration intends to handle conflicts between environmental enforcement and AI energy demand. The answer, at least in this filing, is that AI wins. Whether the court agrees is a separate question. The DOJ's willingness to make the argument at all is the development worth tracking. Sustainability Soundbites Energy Coverage is sponsored by Amazon. Visit the link in our show notes to learn more about Amazon's spotlight on energy. For sponsorship opportunities with Environment and Energy Leader, please reach out to a member of our team.